to get straight into, you could read that at your leisure. I want to get straight into the issue because there's a lot to discuss here. But I wanted to start off by just putting this question into perspective. Why are we asking the question of when a taxpayer can challenge an assessment in the High Court? And there could be many reasons why a taxpayer would want to do that. Time and cost is often one that's cited as going to the High Court directly, as opposed to going through the objection and appeal process and eventually raising whatever your concern is then in the tax court. So there is the perception that it might be quicker, faster, and even cheaper to raise your issue in the High Court directly. And so it might be important to understand, or it is important to understand, at least from that score, when you can in fact do that. Another reason why I think this issue comes up often is I think that there has lately, at least in my experience, there's lately been questions about the jurisdiction of the tax court and whether the tax court can make decisions on certain administrative issues, certain issues that typically you would raise on review in the High Court. Can the tax court do that? We've found, at least in my experience, when you do go through the challenge and you raise these administrative issues or issues of legality of assessment, you often find, in my experience at least, a little pushback on the basis that, if you want to complain about the validity of the assessment and the lawfulness of the assessment, it's not a valid ground for eviction. The tax court can't hear it, so you can't raise it here. You must, in fact, go to the High Court because anything that you complain about, for example, non-compliance by SARS with their obligations pre the assessment, there's not issues that falls within the jurisdiction of the tax court. That might be another reason why people would want to raise issues in the High Court directly. There could be many others, but just to give you an idea as to why this is an issue and why a taxpayer would want to do that. Now, the trouble is why there's no straight, well, I think there's a straight answer eventually. The benefit of hindsight, so hindsight is always 20/20 vision. But there was some contradictory judgments, especially in the last couple of years. Well, I say contradictory, some judgments that created some confusion as to when you can challenge an assessment in the High Court. And of course, you want to be doing that if you can, because you don't want to be in a position where you launch an application for review, whether legality or party or otherwise, to have an assessment or decision by SARS overturned, and then it turns out you're in the wrong court, right, for obvious reasons. Now, before we go into the position as it stands, I think it's important just to give a little bit of context historically as to how this issue was dealt with. Now, before we had the TAA that came into force about October 2012, if I recall correctly, there was two judgments, at least the Metcash one I think is more relevant post 1994, where the court has said that if there's a dispute between taxpayer and SARS, and that dispute raises only a point of law, that dispute can be decided on a point of law, then the special tax court and SARS is not the only persons or people who can make a determination on those issues. In fact, when you look at the legislation at the time, look at the Income Tax Act pre-TAA, there was no legislative interference that said, well, you can't now go and launch your challenge in the High Court because you have to first exhaust the internal remedies. But then comes the TAA, right? So the TAA comes along and introduces the Section 105. And Section 105, as it read, before it was amended in 2015, Section 105 didn't really, from my reading of 105 at the time, really upset the status quo at that stage, because what it said is if you want to dispute an assessment or a decision, you can do so either in terms of the objection and appeal process or by application in the High Court for a review. So again, that didn't really change or interfere in any way with the inherent jurisdiction of the High Court to hear PAJA applications and to hear legality review applications. Now, the trouble is when you look at the 2015 amendment, where Section 105 was amended, it now reads, and to this day, it reads, a taxpayer may only dispute an assessment or decision as described under Section 104, and those are the things that you can object to for those of you not familiar with 104. Then you can do so only in terms of this chapter, which is Chapter 9, which is objection and appeal, as most tax practitioners know it. Noteworthy judgment, most certainly not the first judgment on the issue, but the first noteworthy judgment that I wanted to discuss here is the case of APSA, where APSA and another versus SARS launched a review application in the High Court to have SARS's assessment set aside. Now, just by way of background, what happened here is that SARS sought to apply the GAR. And when they want to apply the GAR, the General Anti-Avoidance Rules, they have to serve you with a Section 80J notice telling you that they want to invoke the GAR and that you must then respond and say why not. And depending on what you respond, then they can go ahead and then raise their assessments accordingly. And that's what SARS did, is they said that ABSA entered into a series of transactions which effectively which had the effect of returning interest tax-free in the form of a dividend, right? And they said that there was no commercial substance to this, and they invoked the GAR, and they said, I'm going to tax those dividends as interest, but before they did that, they served the notice, right? And eventually, what ABSA did is I have to have the GAR notice, which preceded the assessment, which was based on the same grounds as was set out in the GAR notice. I want the court to set these aside. And the basis for the application was, at least so it was argued for ABSA, was that SARS and the taxpayer, ABSA in this case, were in agreement that ABSA did not know about this very thing, this very particular transaction that caused the dividends, or the interest rather, to be exempt. They were ignorant. You can't bring a legality review in the tax court. In other words, you can't approach the tax court directly like you would a high court on a PAJA review or a legality review, because the tax court cannot make decisions on those things. And in RAPA, the SCA says is when we determine exceptional circumstances for us as a high court to direct otherwise, then we must be guided by what is exceptional circumstances and what the Constitutional Court has said what constitutes exceptional circumstances. I'm not going to read this entire passage from the Constitutional Court judgment, but the court said effectively that for something to be exceptional, it must be so out of the ordinary so as to justify departure from the default rule, right? It's not a question of, is it only a point of law? It's a question of, is it so out of the ordinary so as to justify a deviation from the general rule? And that's because of the judgment in the Constitutional Court on a point of law. The question is whether there are exceptional circumstances present that are so out of the ordinary, unusual, or uncommon, so as to justify departure from the default rule, right?
We'll make some remarks on that. But just think it's amazing. The section merely says, and if we read it together, a taxpayer may only dispute an assessment or decision as described in Section 104 in proceedings under this chapter unless a high court otherwise directs. And so the real question here is, what does that mean? And that's what we're worried about. Now, ultimately, the issue is that the default position, and everybody accepts the default position, is that you go for a process of objection and appeal, and you go off to the special income tax court designed for that purpose. On what basis can a high court otherwise direct that, in fact, the decision must, that a case can be brought before it? And of course, what the jurisprudence says, as you see in the questions put up by Nico, the question is, in what sort of circumstances could you approach a high court on the basis that there are exceptional circumstances which justifies the high court from waiving the default position? Now let's start with a simple proposition. And the simple proposition, which belies its complexity, is that you can go to the high court on a point of law. Manifestly, you're not able to go to the high court on a point where facts are in dispute in a tax case, because that's clearly exclusively the province of the special income tax. If there is a legal question which is dispositive of a dispute, which manifestly in this particular case would be such that if that legal question is right, the commissioner would have no authority to do that which he did and which is alleged to be wrong, then that is a matter for a high court to decide. No doubt about it. If there are factual and legal questions intertwined, you've got to go before the special court. That is not a case for the high court. The second question arises, does that then mean that any legal question of any kind relating to a tax dispute, where you could argue the facts are common cause, that such a case would go before, can go before the High Court and not special income tax? Now, I think the answer to that question, in my view, is no. I think that the bar will be set fairly high to ensure that by and large disputes, even of law, go before the tax court, and that only when there's a significant a question of law which raises the powers of the commissioner will the High Court be the appropriate venue. And there is a problematic in our law, though, which is there's a residual review under legality, which is sourced in the Constitution. That does not fall within PAJA. And it may well be, and it's created a lot of confusion in administrative law. But the point about it is, if, for example, you proceed on a legality question, as opposed to a PAJA question, you argue that some decision of an official within SARS, the commissioner, is illegal because it falls outside the scope of the act or the powers. You could probably bring that under a legality review, and then the 180 days wouldn't apply. Of course, you still got to bring it expeditiously, but there's no cut-off limit in the same way. There's the Voltaire's principle, which means you certainly have to bring it relatively expeditiously, but it has slightly less restrictions.